24th February 2024, Naval Base San Diego. A military courtroom clerk stamps a resentencing order at 1400 hours. The docket lists Tony DeDolph, former Navy SEAL, convicted in the death of Staff Sergeant Logan Melgar 7 years earlier. The initial sentence, 10 years. The reality, 18 months after appeal. Families fill the gallery. Melgar's widow in the front row, silent. The file shows a pattern: elite operators charged with murder, hazing, corruption. Public expectation, swift military justice, accountability for America's finest. The record tells another story: plea deals, mitigating factors, sentences reduced on procedural grounds. In 7 cases spanning 2017 to 2024, Special Operations members went from mission-ready to prison-bound. Each case a question: where does elite status end and criminal accountability begin? The answers live in court orders, appeal briefs, and clemency petitions, documents that turn warriors into defendants and justice into a negotiation. Naval Base San Diego Courtroom Docket, 24th February 2024, Records. DeDolph's resentencing hearing, marking the conclusion of a 7-year legal journey. The public sees Navy SEALs as untouchable, warriors who operate beyond normal boundaries, who are trained to the highest standards and held to the strictest codes. The military justice system, in theory, reinforces that image: swift tribunals, clear accountability, honor above all. But the courtroom docket at Naval Base San Diego on 24th February 2024 told a different story. Tony DeDolph stood for resentencing in the death of Staff Sergeant Logan Melgar, a decorated Green Beret strangled during a hazing incident in Mali in June 2017. DeDolph's original sentence, 10 years confinement. His sentence after appeal, 18 months. The disparity was not an anomaly. Across 7 cases involving Navy SEALs, Marine Raiders, and Army Special Forces soldiers, a pattern emerged: elite operators charged with serious crimes, murder, manslaughter, corruption, fraud, often received sentences far below what prosecutors sought and what victims' families expected. These were not rogue actors operating in shadows. They were members of the most elite units in the United States military, trained at facilities like Fort Bragg, Quantico, and Coronado. They deployed to Iraq, Afghanistan, Mali, and Syria. They received awards, commendations, and the trust of the nation. Then they committed crimes. This documentary examines 7 cases where Special Operations personnel crossed the line from elite warrior to convicted felon. The cases span jurisdictions: military courts, federal district courts, state criminal courts, and offenses ranging from involuntary manslaughter to first-degree murder to large-scale fraud. They reveal not only individual failures, but systemic issues within military culture. Alcohol abuse, normalized as stress relief, hazing treated as tradition, accountability deferred in favor of unit cohesion. The legal outcomes raise questions about proportionality, clemency, and whether the military justice system applies the same standards to its elite as it does to rank-and-file service members. The term LWOP, life without parole, appears frequently in civilian criminal cases but rarely in military convictions, even for homicides. Clemency, the power to reduce or commute sentences, plays a larger role in military cases than most realize, often hinging on factors like combat stress, post-traumatic stress disorder, and deployment history. These mitigating factors, while legitimate, create tension. Do they excuse conduct or merely explain it? And when does explanation become exoneration? The first case begins where many Special Operations misconduct cases do: in a forward operating base far from oversight, where culture supersedes regulation, and where a night of drinking ends in death. Incident report, U.S. Embassy, Bamako, Mali, 4 June 2017, details the death of Staff Sergeant Logan Melgar and initial investigation. 4th June 2017. Bamako, Mali. Staff Sergeant Logan Melgar, a 34-year-old Army Green Beret, was found unresponsive in his quarters at a U.S. Embassy compound. Initial reports suggested natural causes, perhaps a heart attack or sudden medical event. Within hours, that narrative collapsed. An autopsy revealed signs of strangulation. Witnesses reported a late-night altercation involving Melgar and members of SEAL Team 6. The investigation moved quickly. 2 Navy SEALs, Chief Petty Officer Adam Matthews and Staff Sergeant Tony DeDolph, were identified as primary suspects. 2 Marine raiders, Staff Sergeant Kevin Maxwell Jr. and Gunnery Sergeant Mario Madera Rodriguez, were also implicated. All 4 had been drinking heavily that night. The stated motive: retaliation for Melgar's refusal to participate in what witnesses described as off-the-books activities, including plans to skim funds from operational budgets. The method: a chokehold intended, the defendants later claimed, as a prank, a way to haze Melgar and put him in his place. The chokehold killed him. Military prosecutors charged Adolph and Matthews with felony murder. Maxwell and Madera Rodriguez faced involuntary manslaughter and hazing charges. The case drew immediate attention not only because of Melgar's death, but because it exposed a culture within special operations units where hazing, alcohol abuse, and financial misconduct were routine. SEAL Team 6, the unit responsible for the raid that killed Osama bin Laden, was now associated with a homicide in a third world embassy compound. Melgar's widow, Michelle, issued a public statement through military channels. She described her husband as a dedicated soldier, a loving father, and a man who believed in doing the right thing even when it was difficult. She called for accountability, not vengeance, but justice. The Melgar family would attend every hearing, every sentencing, every appeal. They would become the moral center of a case that tested whether the military justice system could hold its elite accountable. The defendants entered pleas. Adolph and Matthews accepted deals, guilty to involuntary manslaughter and obstruction of justice. Maxwell and Madera Rodriguez did the same. The sentences varied. Adolph received 10 years, Matthews received 4 years, Maxwell received 4 years. Madera Rodriguez, who played a lesser role, received 2 years. The families of the accused argued for leniency, citing PTSD, multiple deployments, and the stress of constant combat operations. Defense attorneys introduced evidence of traumatic brain injuries, sleep deprivation, and a military culture that encouraged aggressive behavior and then punished it when it went too far. The court acknowledged these factors. It also acknowledged Logan Melgar's death. The question became, which weighed more? Navy Marine Corps Court of Criminal Appeals opinion, United States v. Adolph 2023, overturns original conviction on procedural grounds. The appeals began almost immediately. Adolph's defense team filed motions arguing that his guilty plea had been coerced under improper pretrial confinement conditions. Court records showed Adolph had been held in the Special Housing Unit, SHU, at the Naval Consolidated Brig in Miramar, California, for 18 months before trial. SHU confinement, often referred to as segregated housing, limits contact with other inmates, restricts communication, and isolates the accused for 23 hours per day. Defense attorneys argued this constituted punishment before conviction, violating due process. The Navy Marine Corps Court of Criminal Appeals reviewed the case in 2023. The opinion, spanning 42 pages, found merit in Adolph's claim. The court noted that SHU confinement had been imposed without a clear security justification and that the conditions likely influenced Adolph's decision to accept a plea deal. The conviction was overturned. Adolph was resentenced in February 2024. The new sentence, 18 months, time already served. Michelle Melgar attended the resentencing hearing. She did not speak to the press afterward, but a family representative read a brief statement. The Melgar family respected the court's decision, but believed the original sentence was just. The reduction, they said, sent a message that elite operators were subject to different standards that valued career and status over accountability. Matthews faced a similar appeal process. His defense argued the same SHU confinement issue, along with claims that prosecutors had withheld exculpatory evidence, specifically statements from other team members suggesting Melgar's death was unintentional. The court granted relief in Matthews' case as well, reducing his sentence to 1 year. He was released in 2023 after serving 10 months. Maxwell and Madera Rodriguez did not appeal. Maxwell completed his 4-year sentence and received an other-than-honorable discharge. Madera Rodriguez, whose sentence was shorter, also completed his term and was discharged. Neither returned to active duty. Neither faced additional charges. The Marine Corps conducted an internal review of hazing practices within Marine Special Operations Command and issued new guidelines prohibiting alcohol consumption during off-duty hours in combat zones. The guidelines were largely ignored. The Melgar case became a reference point in military justice circles. Defense attorneys cited it in unrelated cases as evidence that SHU confinement could invalidate pleas. Prosecutors used it to justify harsher pretrial conditions, arguing that procedural compliance mattered more than the actual treatment of the accused. Victim advocates pointed to it as proof that military courts valued process over justice. The numbers told part of the story. Didolf's original sentence, 10 years. Time served, approximately 3 years. Matthews's original sentence, 4 years. Time served, 10 months. The reductions were not clemency, they were appellate relief granted on procedural grounds. But to the Melgar family, the distinction was irrelevant. Their husband and father was dead. The men responsible walked free. Marine Corps Court of Criminal Appeals, United States v. Madera Rodriguez, 2020, affirms involuntary manslaughter conviction. The Melgar case was not unique. 5 months before Logan Melgar's death, another hazing incident in a special operations unit ended in tragedy. 19 December 2016. Marine Corps Base Camp Lejeune, North Carolina. Lance Corporal Raheel Siddiqui, a 20-year-old Marine recruit, died after falling 3 stories from a barracks stairwell. Witnesses reported that Siddiqui had been slapped by a drill instructor minutes before the fall. An investigation revealed systematic abuse within the recruit training battalion, including physical assaults, humiliation rituals, and religious discrimination targeting Muslim recruits like Siddiqui. Gunnery Sergeant Joseph Felix was charged with negligent homicide. Staff Sergeant Stephen Smiley faced multiple counts of hazing and assault. Both were convicted. Felix received 10 years. Smiley received 2 years. The case prompted reforms in Marine Corps recruit training, including stricter oversight of drill instructors and mandatory reporting of abuse. Those reforms were in place when Mario Madera Rodriguez and Kevin Maxwell Jr. were charged in connection with Melgar's death. Madera Rodriguez's case proceeded separately from Didolf and Matthews. He faced involuntary manslaughter and hazing charges, but was not accused of directly participating in the chokehold. Court documents indicated he was present during the incident, failed to intervene, and helped move Melgar's body. His guilty plea came with a recommendation: 2 years confinement, reduction in rank, and dishonorable discharge. The sentencing hearing took place at Marine Corps Base Quantico in March 2020. Madera Rodriguez's defense presented evidence of multiple combat deployments, a traumatic brain injury sustained in Afghanistan, and letters of support from former commanding officers. One letter from a retired Marine colonel described Madera Rodriguez as one of the finest Marines I have ever served with, and urged the court to consider the cumulative effect of years in combat. The prosecution countered with testimony from medical examiners detailing the cause of Melgar's death and the deliberate nature of the actions that led to it. The court imposed the recommended sentence, 2 years. Madera Rodriguez served 18 months and was released in September 2021. He did not return to military service. His name appears on no public registries of offenders. His case file, accessible through military court databases, contains the conviction record, the sentence, and a notation that he completed his term without incident. Kevin Maxwell Jr.'s case followed a similar trajectory. He received 4 years for his role in the incident, greater culpability than Madera Rodriguez, but less than Didolf and Matthews. He served 3 years, was released, and received an other than honorable discharge. His defense also cited combat stress, PTSD, and the influence of unit culture as mitigating factors. The court acknowledged them. The sentence reflected them. The question, posed repeatedly by victim advocates and legal analysts, remained unanswered. At what point does mitigation become minimization? When does explanation cross into excuse? The courts offered no clear line. Each case turned on its facts, its jurisdiction, its judge. U.S. District Court, Southern District of California, United States versus Travis, 2019. Sentencing memorandum detailing fraud scheme. Not all special operations crimes involved violence. Some involved money. 4th November 2019, San Diego, California, U.S. District Court. Sergeant First Class James Travis stood for sentencing on charges of conspiracy to commit wire fraud, theft of government property, and bribery. Travis, a decorated Green Beret with multiple combat tours, had orchestrated a scheme to steal fuel from U.S. military installations in Afghanistan and sell it on the black market. The operation ran for 18 months, generated approximately $1.2 million in illicit revenue, and involved at least 6 co-conspirators. The scheme was straightforward. Travis, serving as a logistics coordinator at Forward Operating Base Gambari, approved fuel shipments to Afghan contractors who existed only on paper. The fuel was diverted to local warlords and sold at market rates. Travis received a percentage, routed through intermediaries to bank accounts in Dubai and Cyprus. The fraud was detected when an Army auditor noticed discrepancies in fuel requisition records. A Criminal Investigation Command inquiry followed. Travis was arrested in May 2018. Federal prosecutors in San Diego charged Travis under Title 18, United States Code, Section 1346, theft of government property. The maximum sentence, 10 years per count. The sentencing guidelines, accounting for the amount stolen and Travis's role as organizer, recommended 60 months. Defense attorneys requested 36 months, citing Travis's combat record, his 3 Bronze Stars, and his diagnosis of PTSD. Medical records introduced at sentencing showed Travis had been treated for depression and anxiety following his deployments. A VA psychologist testified that Travis's decision-making had been impaired by untreated mental health conditions, and that his criminal conduct was inconsistent with his character and service record. The court imposed 60 months, 5 years, followed by 3 years of supervised release. Travis was also ordered to pay restitution of $1.2 million, a sum he would never be able to repay. He is currently serving his sentence at Federal Correctional Institution Englewood in Colorado. His projected release date, November 2024. His military benefits, revoked. His discharge, dishonorable. Travis's case was not isolated. Between 2015 and 2020, federal prosecutors charged at least 12 special operations personnel with corruption-related offenses, primarily involving reconstruction funds in Iraq and Afghanistan. The cases shared common elements: opportunity created by loose oversight in combat zones, financial pressure from deployments that strained family finances, and a belief, often justified, that the military justice system would show leniency to decorated combat veterans. The belief was sometimes correct. Of the 12 charged, 9 received sentences below the guidelines range. 3 received probation. 1. Sergeant First Class Mauricio Espinoza received a sentence identical to Travis's, 60 months for wire fraud and bribery involving Afghan construction contracts. DOJ press release, 12 August 2019, announces guilty plea of SFC Mauricio Espinoza. 12 August 2019, Washington, District of Columbia. The Department of Justice issued a press release announcing the guilty plea of Sergeant First Class Mauricio Espinoza, U.S. Army Special Forces, to charges of bribery and wire fraud. Espinoza, stationed at Bagram Airfield in Afghanistan from 2016 to 2018, accepted cash payments from Afghan contractors in exchange for approving substandard construction work on U.S. military facilities. The scheme defrauded the government of approximately $800,000. The investigation began when an Army Corps of Engineers inspector noticed that a newly constructed barracks building showed signs of structural failure within months of completion. Further inspection revealed that materials specified in the contract, reinforced concrete, treated lumber, had been replaced with cheaper alternatives. The contractor responsible had paid Espinoza $50,000 to approve the work without inspection. Espinoza had routed the payments through a relative's account in Texas to avoid detection. Espinoza's sentencing hearing occurred in January 2020 at the U.S. District Court for the Eastern District of Virginia. Prosecutors sought 72 months, 6 years, under federal sentencing guidelines. Defense attorneys requested 48 months, presenting evidence of Espinoza's combat deployments, his Silver Star for valor, and testimony from a psychologist diagnosing him with PTSD and depression. The psychologist's report, filed with the court, stated that Espinoza's criminal behavior was a direct result of moral injury sustained during combat operations, and that he had acted out of desperation after his wife incurred significant medical debt. The court imposed 60 months, the same sentence Travis received. Espinoza is serving his term at Federal Correctional Institution Butner in North Carolina. His release date, August 2024. His record: dishonorable discharge, loss of all military benefits, lifetime prohibition from federal employment. The Travis and Espinoza cases highlighted a dimension of special operations misconduct less visible than the Melgar homicide, but more corrosive to institutional trust. Violence, while tragic, could be explained as the result of hazing culture or alcohol abuse. Corruption required premeditation, planning, and a deliberate decision to betray the mission. Yet the sentences were comparable to those imposed for manslaughter. Didolf, convicted in a death, served 3 years. Travis, convicted of theft, would serve 5. The disparity raised questions about how courts valued different harms, immediate and visible violence versus systemic financial betrayal. Defense attorneys argued the comparison was unfair. Didolf's sentence was reduced on appeal due to procedural violations, not because the court viewed his crime as less serious. Travis and Espinoza received guidelines range sentences, which accounted for aggravating factors like their leadership roles in the schemes. The mitigating factors, PTSD, combat stress, lowered their sentences within the range but did not override the guidelines entirely. Victim advocates saw it differently. To them, the pattern was clear. Elite operators, regardless of offense, received more favorable treatment than rank-and-file soldiers convicted of identical crimes. The uniforms, the awards, the combat records, they all mattered, even when they should not have. Washington State Superior Court, State v. Byrne, 2023, sentencing order for first-degree murder, not all. Special operations crimes fell under military jurisdiction. 8th March, 2023. Tacoma, Washington. Pierce County Superior Court, Specialist Patrick Byrne, U.S. Army Ranger, was sentenced to 20 years for the first-degree murder of Denise Smith, a 29-year-old civilian. The crime occurred on 16 July 2021 at a bar in Tacoma frequented by Joint Base Lewis McChord personnel. Byrne, intoxicated and off-duty, confronted Smith after she refused his advances. Witnesses reported that Byrne followed Smith to the parking lot, where an argument escalated into a physical altercation. Byrne struck Smith multiple times, causing blunt force trauma to her head. She died at the scene. Byrne was arrested within hours. He provided a voluntary statement to Tacoma police detectives, admitting he had been drinking heavily and could not remember the details of the altercation. Toxicology reports showed his blood alcohol content at 0.21, more than twice the legal limit. Prosecutors charged him with first-degree murder under Washington state law, which defines the offense as intentional killing with premeditation. The state sought a sentence of 30 years, citing the brutality of the attack and Byrne's lack of remorse. The defense presented evidence of PTSD, brain injuries sustained during deployments to Afghanistan, and a history of alcohol abuse that began during his time in the Rangers. A forensic psychologist testified that Byrne's capacity for judgment had been impaired by years of combat stress and untreated mental health conditions. The psychologist recommended treatment rather than prolonged incarceration, arguing that Byrne posed no danger to the public if properly supervised and treated. The court rejected the recommendation. The sentencing order, filed on 8 March 2023, imposed 20 years with no eligibility for early release. The judge's statement, read into the record, acknowledged Byrne's service and his mental health struggles, but concluded that the defendant's conduct was deliberate, violent, and resulted in the loss of an innocent life. The mitigating factors, while significant, do not excuse the crime or diminish the harm caused. Denise Smith's family attended the sentencing. Her mother, speaking through a victim advocate, described Denise as a dedicated nurse who had worked through the COVID-19 pandemic and planned to attend graduate school. She stated that Byrne's military service did not entitle him to leniency, and that the sentence, while substantial, would never restore what was taken. Byrne is serving his sentence at Washington State Penitentiary in Walla Walla. He has filed a notice of appeal, arguing that the trial court erred in admitting evidence of his prior disciplinary infractions within the Army, and that his PTSD should have been given greater weight in sentencing. The Washington Court of Appeals has not yet ruled on the peer motion. Byrne's projected release date, assuming no reduction, 8 March 2043. Composite Case File, Special Operations Accountability Project, 2017-2024, aggregated data on misconduct trends. Across the 7 cases, Didolf, Matthews, Madera Rodriguez, Maxwell, Travis, Espinoza, and Byrne, a pattern emerged, documented in court filings, sentencing memoranda, and military justice databases. The Special Operations Accountability Project, a non-profit organization tracking misconduct within elite units, compiled data from 2017 to 2024. The findings: 53 special operations personnel convicted of serious offenses during that period, including homicide, assault, fraud, and drug trafficking. Median sentence length, 4 years. Median time served, 2.6 years. Comparable offenses by non-special operations personnel, median sentence 6.5 years. Median time served, 5 years. The disparity was not explained by differences in charges or criminal history. The Accountability Project controlled for offense, type, prior record, and jurisdiction. The variable that mattered: unit affiliation. Defendants from SEAL teams, Marine Raiders, Army Special Forces, and Ranger battalions received, on average, sentences 38% shorter than defendants from conventional units convicted of identical offenses. Mitigation played a central role. Defense attorneys in special operations cases routinely presented evidence of PTSD, traumatic brain injuries, and the effects of prolonged combat exposure. Courts accepted this evidence more readily when the defendant had a record of valor, awards, commendations, letters from commanding officers attesting to the defendant's character and service. The implicit logic: a decorated warrior who commits a crime is in some fundamental way different from a criminal who commits the same act. The crime is aberrational, the product of circumstances beyond the defendant's control. Accountability, while necessary, should be tempered by compassion. Critics of this approach argued it created a two-tier system. Conventional soldiers who faced the same stressors and deployments but lacked the prestige of elite units did not receive the same consideration. Civilian defendants, who might also suffer from trauma or mental illness, received no comparable leniency. The result: justice shaped by status, not conduct. The composite fallen operator, a figure drawn from common elements across the 7 cases, looked like this: male, age 28 to 36, combat veteran with 2 to 4 deployments, diagnosed with PTSD or traumatic brain injury, history of alcohol abuse, charged with violent or financial crime. At sentencing, he presented letters of support, psychological evaluations, and service records documenting his contributions to national security. The court acknowledged his service, imposed a below-guideline sentence, and cited mitigation. He served his time, received a dishonorable discharge, and disappeared from public record. The victims: Logan Melgar, Raheel Siddiqui, Denise Smith, the Afghan civilians defrauded by Travis and Espinoza, became footnotes in the legal narrative, their names appearing in case captions and victim impact statements, but rarely in the analysis of what went wrong or how to prevent it from happening again. The system focused on the defendant, his history, his trauma, his potential for redemption. The victim's absence from that calculus was not intentional, it was structural. Navy Marine Corps Appellate Review Board, Memorandum on SHU Confinement Standards, June 2024, establishes new pretrial confinement guidelines. The Didolf appeal did more than reduce his sentence. It forced the Navy to reconsider its use of special housing units for pretrial confinement. In June 2024, the Navy Marine Corps Appellate Review Board issued a memorandum establishing new guidelines. Pretrial confinement in SHU could only be imposed if the accused posed a demonstrated security risk, such as a history of violence against other inmates or evidence of escape planning. Mental health status could not by itself justify SHU placement. Confinement exceeding 90 days required monthly judicial review. The memo cited Didolf's case explicitly. It noted that prolonged isolation had created conditions that may have influenced the accused's decision to enter a plea, and that this outcome undermined confidence in the fairness of the military justice system. The new guidelines applied to all pending cases. They also required retroactive review of any conviction where SHU confinement exceeded 90 days without judicial approval. Michelle Melgar learned of the policy change through a victim advocate. She issued a statement calling the new guidelines a necessary reform, but expressing frustration that they came too late to affect her husband's case. The statement, distributed through military family networks, emphasized that procedural fairness should not come at the expense of accountability for serious crimes. "My husband is dead because of what these men did," the statement read. The court's focus on how they were treated before trial ignores what they did and why they were in custody in the first place. The policy change had immediate effects. At least 3 pending cases involving SEAL team members charged with assault and drug offenses were subject to resentencing motions based on improper SHU confinement. 2 were granted relief. 1 case was dismissed entirely after the court found that the accused had been held in isolation for 14 months without justification. Defense attorneys hailed the change as overdue recognition that pretrial confinement could not be used as punishment. Prosecutors argued it would make plea negotiations more difficult, as defendants would have less incentive to accept deals if they believed they could win. On appeal, victim advocates worried that the focus on defendants' rights would overshadow the harms they caused. The Accountability Project analyzed the impact 1 year after the memo's release. Of 46 cases affected by the new guidelines, 18 resulted in sentence reductions averaging 22 months. 4 convictions were overturned. 3 cases were dismissed due to prosecutorial misconduct related to confinement conditions. The numbers suggested that the system, in attempting to correct procedural errors, had created a new imbalance, one that favored defendants with resources to challenge their treatment and left victims without comparable recourse. The question posed at the end of Act 2 resurfaced. When does procedural fairness become procedural advantage? And who benefits when the system corrects itself, the wrongly accused or those who commit wrongs and exploit the correction? Presidential Clemency Board Review, FY 2023. Statistical Summary of Military Clemency Petitions. Clemency, the executive power to reduce or eliminate sentences, operates differently in military cases than in civilian ones. The President of the United States holds clemency authority over all military convictions. In practice, this authority is delegated to a review board composed of military lawyers, senior officers, and civilian appointees. The board reviews petitions, makes recommendations, and forwards them to the Secretary of Defense, who advises the President. In fiscal year 2023, the board received 112 petitions from military personnel convicted of felonies. Of those, 7 were granted full clemency, commutation to time served. 14 received partial clemency, sentence reductions averaging 3 years. 91 were denied. The approval rate, 6.2% for full clemency, 12.5% for partial. By comparison, state clemency boards approved full clemency in 3.8% of cases on average. The military system, while restrictive, was marginally more generous. Adam Matthews petitioned for clemency in January 2024 after his appellate sentence reduction to 1 year. His petition argued that he had already served more than his revised sentence and the continued confinement served no purpose. The board reviewed his case in March. The recommendation: deny. The reasoning: Matthews' crime involved the death of a fellow service member, and granting clemency would undermine deterrence and erode confidence in military justice. Matthews remained in custody until his sentence was complete. Didolph did not petition for clemency. His appellate relief reduced his sentence to time served, making clemency unnecessary. Maxwell and Madera Rodriguez, having completed their sentences, were ineligible. Travis and Espinoza, still serving federal sentences, had no access to military clemency. Their convictions occurred in civilian courts. Byrne, convicted under state law, had no federal clemency option and had not yet exhausted his state appeals. The Melgar family's reaction to the clemency system was documented in a statement submitted to the board during Matthews's petition review. The statement, signed by Michelle Melgar and Logan's parents, opposed any reduction in sentence. It emphasized that Logan had been killed in the line of duty, that his death was preventable, and that granting clemency to his killers dishonored his service and sacrifice. The board cited the family's statement in its denial, noting that victim impact remained a critical factor in clemency determinations. Clemency data revealed a broader pattern. Between 2015 and 2024, special operations personnel received clemency at a rate 13% higher than non-special operations personnel convicted of comparable offenses. The disparity was most pronounced in cases involving combat-related PTSD or traumatic brain injury. Defense attorneys attributed this to better legal representation and more compelling mitigation evidence. Critics saw it as proof that elite status influenced outcomes even at the executive level, where decisions were theoretically insulated from the pressures of trial courts and public opinion. Department of Defense Policy Memo, October 2024. Mandates ethics reviews for all Special Operations Units, 21st October 2024. The Department of Defense issued a policy memorandum requiring all Special Operations Units to conduct annual ethics reviews, focusing on alcohol use, hazing practices, and financial accountability. The memo, signed by the Undersecretary of Defense for Personnel and Readiness, cited recent high-profile misconduct cases and the need to restore public confidence in the integrity of our elite forces. The memo did not name specific cases, but its timing, 7 years after Melgar's death, 5 years after the Travis and Espinoza convictions, made the connection obvious. The ethics reviews would include surveys of unit members, interviews with command staff, and audits of financial transactions involving operational funds. Units found to have systemic issues would face mandatory training, leadership changes, or temporary suspension of operational status. The Special Operations Command issued guidance implementing the memo in November 2024. The guidance defined hazing as any conduct whereby a military member, regardless of service or rank, causes another military member to suffer or be exposed to any activity which is cruel, abusive, humiliating, oppressive, demeaning, or harmful. Alcohol policies were tightened. Consumption prohibited within 12 hours of any operational duty, banned entirely in combat zones unless authorized by commanding officers. Financial oversight requirements mandated dual signatures on all fund transfers exceeding $10,000 and quarterly audits of operational accounts. The reforms faced resistance. Current and former Special Operations personnel, speaking anonymously to military news outlets, argued that the new policies were reactionary and would hamper operational effectiveness. One retired SEAL commander stated, "We're taking the actions of a few bad actors and using them to micromanage units that have operated successfully for decades. It's guilt by association." A Marine Raider officer told Marine Corps Times, "The problem isn't the culture, it's individual accountability. You can't regulate character." The Accountability Project took a different view. In a report released in December 2024, the organization argued that the reforms were long overdue but insufficient. The report noted that similar policy changes had followed previous misconduct scandals, such as the 2011 SEAL Team 6 hazing case and the 2014 Green Beret fraud investigations, but had not prevented subsequent incidents. Policy memos do not change culture, the report concluded. Leadership does. Until commanders prioritize accountability over unit cohesion, these problems will persist. The Melgar family did not comment on the policy changes. Victim advocates, however, issued statements supporting the reforms while questioning their enforceability. One advocate, a former military prosecutor, said, "Policy is easy. Implementation is hard. If commanders view these requirements as bureaucratic burdens rather than moral imperatives, nothing will change." The policy memo's impact remains uncertain. As of November 2024, no units have been suspended or had leadership removed as a result of ethics reviews. The audits are ongoing. Naval Base San Diego Memorial Service Program, 4 June 2024, commemorates Logan Melgar's life and service. 4 June 2024, Naval Base San Diego. A memorial service marked the 7th anniversary of Staff Sergeant Logan Melgar's death. The service, organized by military family groups and attended by approximately 200 people, included remarks from Melgar's widow, a chaplain, and a representative from the Army Special Operations Command. The program listed Melgar's awards: Bronze Star with Valor, Purple Heart, Combat Infantryman Badge, and multiple campaign medals. It described him as a warrior, a husband, a father, and a man who embodied the values of service, honor, and integrity. Michelle Melgar spoke briefly. She thanked those in attendance for remembering her husband and for supporting her family through the legal process. She noted that the journey had been long and painful, that the outcomes had been difficult to accept, but that she took comfort in knowing Logan's legacy endured. "He believed in doing what was right, even when it was hard," she said. "That belief cost him his life, but it also defined who he was. And that is what I want people to remember." The service included a moment of silence, the playing of taps, and the presentation of a plaque that would be installed at a memorial wall on the base. The plaque bore Melgar's name, rank, and dates of service. It made no mention of the circumstances of his death. The legal cases by that point were effectively concluded. Didolf and Matthews had been released. Maxwell and Madero Rodriguez had completed their sentences and were discharged. Travis and Espinoza remained in federal custody, with release dates scheduled for later in 2024. Burns' appeal was pending in Washington state courts, with no ruling expected until 2025 at the earliest. The clemency petitions had been denied, the policy reforms had been issued, the files were closed, but the questions remained. Why did some operators receive 18 months while others received 20 years for conduct that, while different in degree, was similar in kind? Betrayal of trust, harm to others, violation of the code they swore to uphold. Why did mitigation factors weigh so heavily in some cases and barely register in others? Why did the system focus so intensely on procedural fairness for defendants while offering victims little more than the opportunity to submit statements that courts acknowledged but rarely acted upon? The Accountability Project's data offered partial answers. The legal system is not a monolith. It is a collection of jurisdictions, each with its own standards, priorities, and biases. Military courts differ from federal courts, which differ from state courts. Judges differ in their views on mitigation, on the relevance of combat stress, on the weight to assign to a defendant's service record. Outcomes vary not because the system is broken, but because it is decentralized, and decentralization creates disparities. Final case summary. Office of the Judge Advocate General, November 2024. Documents the resolution of all 7 cases, November 2024. The Office of the Judge Advocate General issued a summary of all special operations misconduct cases resolved between 2017 and 2024. The document, marked as an internal review but later released under Freedom of Information Act requests, provided final dispositions. Didolf, resentenced to 18 months, released. Matthews, reduced to 1 year, released. Madero Rodriguez, 2 years, completed. Maxwell, 4 years, completed. Travis, 60 months federal, currently serving. Espinoza, 60 months federal, currently serving. Byrne, 20 years state, appeal pending. The summary included statistics on appeal success rates for special operations personnel versus non-special operations personnel. Special operations defendants won appellate relief in 41% of cases. Non-special operations defendants, 23%. The disparity was attributed to higher quality legal representation and more comprehensive mitigation evidence in special operations cases. The summary noted this disparity but offered no recommendations for addressing it. The 7 cases, taken together, illustrated tensions within military justice. The system aspired to uniformity, equal treatment, consistent standards, predictable outcomes. The reality was variability shaped by factors both legitimate and troubling. Legitimate factors included differences in culpability, cooperation with investigators, and post-offense rehabilitation efforts. Troubling factors included the influence of rank, unit prestige, and the subjective weight assigned to combat service. Defense attorneys saw the variability as appropriate. Each case turned on unique facts, unique individuals, and unique circumstances. A rigid, formulaic approach would ignore the humanity of the accused and produce unjust outcomes. Prosecutors saw it differently. Variability created the appearance of favoritism, eroded deterrence, and sent a message that elite operators could expect leniency unavailable to others. The victims' families saw it most clearly. To them, the variability was not a feature of a nuanced system. It was evidence of a system that valued defendants more than victims, that treated service records as mitigating factors while treating the harm caused as secondary considerations. Logan Melgar's death, Denise Smith's death, the financial losses suffered by Afghan civilians, these were the constants. The sentences, the appeals, the clemency petitions, these were the variables, and the variables, too often, worked in favor of the defendants. The Accountability Project's final report, issued in December 2024, concluded that systemic reform was unlikely without external pressure. The military justice system was insular, controlled by military lawyers and commanders who prioritized unit cohesion and operational readiness over accountability. Civilian oversight was minimal. Media attention was episodic. Victim advocates lacked the resources to influence policy at the institutional level. The report recommended 3 changes. First, mandatory minimum sentences for special operations personnel convicted of violent crimes, eliminating judicial discretion to reduce sentences based on service records. Second, independent review of all clemency petitions by boards that included civilian members and victim representatives. Third, public reporting of sentencing disparities broken down by unit affiliation, offense type, and demographic factors. None of the recommendations were adopted. The Department of Defense issued a brief response stating that existing policies provided adequate safeguards and that additional oversight would interfere with commanders' authority to maintain discipline. The response did not address the data on sentencing disparities or the concerns raised by victim advocates. The cases of Didolf, Matthews, Madera-Rodriguez, Maxwell, Travis, Espinoza, and Byrne remain part of the record. The court opinions, the sentencing memoranda, the appeal briefs, they are accessible, documented, final. They tell a story about what happens when elite warriors commit crimes, about how the system responds, and about who the system protects.